5 seconds to go. Start. Thus, the appeal appears to me meritorious and it is allowed. The impugned order passed by the learned court below on 10th May 2022 in miscellaneous case number 281 of 2021 is hereby set aside. The application under section 5 of the Limitation Act filed by the appellant defendant as well as the application under Order 9 Rule 13, the miscellaneous case bearing number 28 of 2021 is allowed. The judgment entitled suit number 8305 of 2014 dated 24th July 2019 is hereby also set aside. Appellant is directed to appear before the learned court below within 1 week from the date of passing of this judgment along with his witnesses and to proceed with these suits without any adjournments. Learned court below is directed to allow the defendant appellant to adduce his witness for a single day and also fixed another date for arguments, and he is also directed to dispose of the title suit by 30th November 2022 after hearing both the parties by pronouncing a contested judgment with the framing of issues. Accordingly, the instant appeal and the connected application, if pending, is disposed of. I have had the privilege of going through the draft judgment prepared by my learned brother. I am in full agreement with the conclusions that his lordship has reached and has also the reasons advanced by him in reaching them. While considering whether an applicant has been able to show sufficient cause for condonation of delay in preferring an appeal or application or sufficient cause for not being present in court when an ex parte decree or order was passed against him, the principles of law laid down by the Supreme Court and the High Courts in various decisions down the years have to be collated, and some kind of a uniform principle or standard identified and applied by the courts. It is true that a litigant does not gain anything by abstaining from litigation or not appearing in court. The litigant runs a very serious risk if the delay is not condoned or if his effort to set aside the ex parte decree or order does not meet with success. But very often a speculating litigant would take this risk. Say, for example, a tenant whose tenancy has been lawfully terminated. He knows that he has no known right to remain in the premises. An eviction decree is likely to be passed. It would suit him fine to abstain from attending court hearings, suffer the decree ex parte, and then take a chance to set it aside. Even after suffering a contested or ex parte decree, it might suit him to refrain from preferring an appeal and jump into the court the moment the landlord was trying to execute the decree. Therefore, in such type of cases, an examination of the merits of the applicant's case is necessary while considering whether he had reasonable cause. Usually, a litigant entrusts his case to a lawyer expecting that he would take steps in the matter. Stop.